Hear you. Court of Appeals of the State of Michigan is now in session. Appearing remote, the Honorable Christina Robertson-Garrett, the Honorable Randy J. Wallace, the presiding Honorable Brock A. Schwartzel. All persons having business here and draw near, give attention, they shall be heard. God save the United States, the State of Michigan, the Honorable Court, please be seated.
Good morning and welcome to the second day of the Lansing case call for the Michigan Court of Appeals. I am joined today by Judges Garrett and Wallace. We appreciate everyone who's been able to make it in person or remotely. I am aware that the flu and other stuff is going through. My secretary and my wife are both down. So I very much appreciate that if you've been able to make it, thank you. We have a busy case call today, so we're going to get right to it. I do want to reiterate that oral argument is not a time to rehash all the arguments in your brief. We've read your brief, we've read the pertinent parts of the case law and the record, and we've had the benefit of bench memos and research reports prepared by our staff. This is really a time to hit one or two key points, maybe update us on something that has happened between when you filed your brief and today, but most importantly, answer any questions that we might have for you. And then I do also want to reiterate that if there's anybody involved in a case that is either a minor or a victim of domestic abuse or any kind of abuse or neglect, please don't use their names in open court. Everything that we do today is recorded and will be uploaded to YouTube and apparently, saved forever and become part of ChatGPT one day. So with that, I will call the first case. It's the 15th matter on our docket today, docket number 370947, People v. McBroom. I believe we have remote argument on both sides.
Good morning, Your Honor. John Roach appearing on behalf of defendant appellant Jonathan McBroom.
Good morning. I think we have Ms. McLaren? Okay.
Janet McLaren on behalf of the people.
Okay. Mr. Roach, you have the floor.
Thank you, Your Honor. And I'd like to thank the court again for allowing me to appear via Zoom for this argument this morning. To that end, and with Your Honor's advice, I have really nothing to add to the brief that I've submitted. I would rely on the brief this morning, and I'm here to answer any questions that the panel might have for me from this case.
Judge Garrett.
I have no questions. Thank you.
All right. Ms. McLaren.
Thank you very much, Janet McLaren on behalf of the people. I also will rely on my brief unless there are questions.
Any questions?
No, thank you.
No
All
questions.
right, Mr. Roach, I don't believe you have anything to respond to, so
I do not.
The case will be submitted. We appreciate you showing up to answer questions.
Thank you, Your Honor.
And Ms. McLaren, I see that you're not going anywhere.
I am not.
16, docket number 372430, People v. Baden. I believe we have Mr. Ambrose here. We appreciate you showing up today, Mr. Ambrose. As soon as you get settled, you'll have the floor.
It's Ronald Ambrose appearing on behalf of Mr. Baden. And there's a lot has happened since the briefs have been filed in this case. Most notably was the supplemental authority supplied by the prosecution on People versus Hughes. It effectively is controlling in terms of a facial challenge to Mr. Baden's claim. There are still a number of things happening in the federal courts. Some of the cases that I have cited, there are, I don't know if the court wants me to go into like giving the citations to the new.
No, we have the citations. Thank you.
Or the newer cases that have, let me just put it on the record just so that it happens. And I cited United States versus Diaz. The United States Supreme Court has denied cert on that case. That's a new development, and the citation to that is 145 S Court 2822. United States versus Du Bois. They reaffirmed after remand, and that case site is 139 F 4th 887. We also have United States versus Pierce. The only citation to that is Westlaw site 2025 WL 1721074. And that's an interesting case. It's pending in the United States Supreme Court right now. The Pierce case is, and at the end of their decision, they said, at bottom, we require clearer instruction from the Supreme Court before we may reconsider the constitutionality of Section 922G1, which is the federal counterpart to our felon in possession statute. United States versus Freeman, it's a case in favor of Mr. Baden. That case is currently pending in the Seventh Circuit. If I was assigned on this matter as a substitute counsel once the application had been filed by prior counsel. And I really didn't get into the as applied issue in the case, because as applied, this was a self-defense type of a situation, and we have People versus Dupree from about 15 years ago. That citation is 486 Mich 693, and in that case,
But
says,
if I recall, you didn't raise an as applied.
I didn't.
Okay, then
I mean,
why are you bringing it up? I mean,
well,
you know, we can't bring up new claims at oral argument.
Yeah, I would like the court to remand so that I can fully brief that issue. Like I said, I wasn't the initial attorney on it, and maybe, you know, with hindsight, after the application was, after I got appointed, maybe I should have filed a motion to remand or something along those lines. But I think it's a valid claim
Okay.
that may need additional information on, you know, in the lower court while Hughes is pending. Hughes is pending in the Michigan Supreme Court right now. And the prosecution in that case is ordered to answer by January 16th.
Okay.
So that's the update that I have.
Did you want to address how People v. Langston affects the case?
You
If
know
you're
what?
familiar with it?
I am, but not totally.
That's okay.
Okay.
Thanks.
Judge Garrett, any questions?
I do not. Thank you.
I believe Langston was felony murder.
If you haven't reviewed it, that's fine.
Yeah, I have.
Thank you.
Okay.
Let's hear from Ms. McLaren, and then you'll have time for a rebuttal.
Okay.
Thank you. I would just rely on my brief along with the supplemental authority of Hughes. I would just note that Hughes also addresses some of the federal cases that have been looked at as well.
Okay. It does appear that a court above us will be deciding this ultimately. So, Mr. Ambrose, if you want to come back, and I'm not sure there's much more to reply from what Ms. McLaren had to say.
No, but I agree with your comment that, yeah, I don't know if the court is inclined to hold this in abeyance or remand it back down.
We typically, I mean, there's a lot of things that the Supreme Court considers, and we usually don't hold everything. If we held everything in abeyance that could be held in abeyance under that circumstance, we'd have a lot of cases being held in abeyance. Typically what happens is, you know, whatever happens, one side will seek an application, and then if the Michigan Supreme Court thinks it should be held in abeyance, they'll do so. So, but we'll just kind of have to see how the chips fall.
Very
Okay.
good.
Thank you.
Appreciate it. Thank you.
Thank you.
Thank you.
That case is submitted. Moving on to the 17th matter of our docket this month, docket number 374098, People v. Wilson. I believe both are also appearing remote. So we have Ms. Sharon, and I think we're waiting for Ms. Bloomquist. Okay. All right, Ms. Sharon.
Good morning, Your Honor, and thank you to this honorable court. Alona Sharon on behalf of the defendant appellant, Mr. Wilson, and thank you to the court for allowing me to appear via Zoom. Can I just ask if you can hear me okay?
We can hear you.
Okay, thank you, Your Honor. Your Honor, I understand from the court, and I've certainly been there enough to know not to repeat everything that's in my brief. I do just want to address a couple points that Ms. Blomquist makes in her reply brief. And then, of course, if the court has any questions, I would be happy to answer. I first want to address this sort of suggestion from Ms. Blomquist that the granite bench is, in fact, a headstone. The photo that's attached to the brief, I frankly have never seen before. I get a copy of the court file, the attorney file. I request a copy of the PSI from MDOC. I obviously had a copy of the bill for the funeral services and also the one-page document that's the bill for the bench. I've never seen the photo of this headstone before. I mean, granted, it was attached to the application, but I think it's very challenging to believe that what is referenced as a bench, both in the paperwork and in the transcripts, Your Honor, is in fact a headstone. Also,
before you get into that, I think, and I guess Ms. Bloomquist can clarify, I think there was an assertion that that photo was part of the pre-sentence investigation report. Is that, Ms. Schroner, do you disagree with that, or?
What I can tell the court is that a bill is referenced at the time of sentencing that is part of the pre-sentence investigation report. There's nothing in the transcript to suggest that there's a photo of the item being purchased that's referenced as a bench, but it really appears to be a headstone. And I think there's really nothing in the record, Your Honor, to support Ms. Blomquist's argument that what is being billed as a $20,000 granite bench is in fact the headstone. I would also point out to the court, if you look at the documents that are submitted by Ms. Blomquist, if you look at the page of the appendix that has the photo of what appears to be a headstone, in the upper left-hand corner, there's like what I would think is a model number for the item. It says BCS 015-033 and BCS 018-001. But if you look at the granite bench bill, which we've both provided to the court, you can see where it says granite bench in the middle of the form. And there is what appears to be what I would assume is an item or model number of BCBN002, which does not match the documentation that's on the picture that appears to be a headstone. So I also, Your Honor,
let me ask you this, Ms. Schroen.
Yes.
If this bench were a replacement for a headstone, and basically the bench was, instead of getting a headstone, was there a problem here?
Your Honor, I believe that there is. First of all, and respectfully, Your Honor, number one, I just don't think there's anything in the record to support that. I think the record.
Get it, but let's just assume for purposes of my argument.
Sure.
Question that bench is a replacement for what would traditionally be a headstone.
Sure. So, Your Honor, I think even the Garrison case that Ms. Blomquist cites is talks about reasonableness, right? And I think, if you look at the documentation for the bench or headstone, whatever you want to call it, it's a solid granite bench made of premium granite at the cost of nearly $17,000, right? We top off at about 20 for sales tax and bench installation. And Your Honor, I think restitution has to be to a certain extent reasonable, and I'm not trying to be cute, but if the family had decided to get a headstone that was encrusted with crystals, would a defendant be required to provide restitution for something that is that extravagant, maybe is the appropriate word? And I don't think that that's the intention of restitution. And when we read that restitution is supposed to be reasonable, Your Honor, I think there's a reason that we use the word reasonable. It's there has to be some cap on what is a reasonable expenditure, Your Honor. Also, if you look at the transcript, and I don't know if the court has it before you, at sentencing, at page 47, the court, there's conversation between the court and the lawyers, and the court is trying to clarify the different expenses, right? There's a bill of $20,000 and change for funeral expenses, and then the bill for the bench. And the prosecutor acknowledges that the $20,000 and change is in addition to the funeral expenses. So the judge says to Mr. Roberts, who is the APA who's present, so the granite bench was $16,807. Okay. So the $20,913.92 is in addition to the funeral expenses. That's what I'm getting. Is that correct, Mr. Roberts? And Mr. Roberts responds, that is correct. Yes, Judge. This is at page 47. Lines 15 through 20. So I think there's an acknowledgement on behalf of the prosecution at sentencing that this expense is above and beyond, Your Honor, the funeral expenses. And those, Your Honor, were, I think, the main points that I wanted to make. There has to be a sense of reasonableness to the expenditures. I do not believe there is anything in the record to support that this headstone is what is being billed as a $20,000 bench. And quite frankly, Your Honor, I can't even find a headstone above $5,000. So to suggest that this is for a headstone, I think is really lacking in merit. And I think also, which is mentioned in the brief, if you look at what the definition of funeral is, a premium granite bench certainly does not fall within the definition of what a funeral expense would be when we're looking at the regular definition of funeral, Your Honor.
Okay, I think also there was an argument in the defendant's brief that this expense also should not have been allowed because the bench had not been completed, installed, and included as part of the funeral service itself. When I saw that, I thought that doesn't make any sense, only because many of the funeral services I've been to, there is no headstone yet because, typically a funeral service will happen within a week or so of someone's passing, and getting a headstone that quickly picked out and customized and installed just is not reasonable or not possible. So tell me why my understanding is wrong.
So, well, Judge Schwartzel, I would never tell you that you're wrong. I might just say that I disagree with you.
People tell me I'm wrong on a almost minute by minute basis in my life. So don't feel bad.
So, Your Honor, that argument is an extension of what we look at as the definition of funeral, right? So funeral is not defined within the restitution statute. I don't think that's really up for argument. But the dictionary definition that I located for funeral is, quote, the observance held for a dead person, usually before burial or cremation. And so if you're looking at the definition of funeral, that's kind of where that argument came from. Does
that argument sweep so broadly that basically no headstones, set aside the bench issue, but just no headstones at all would ever be part of restitution, because as a practical matter, headstones just aren't available that quickly?
So, Your Honor, I guess my answer would be I respectfully think that's a question for another day because I don't think in this case there's any record evidence to support that $20,000 is for the headstone. But if the court wants me still to address it, my answer would be twofold. One is I think that the price of the headstone still needs to be reasonable to award restitution for it. And so fortunately I haven't had the experience of having to select a headstone. I don't know the speed with which that's typically done, and certainly different cultures have different and religions have different practices. I just think it's an answer I'm not necessarily comfortable giving because I just don't think, respectfully, Your Honor, that it's relevant to the case that's before the court today.
Okay. No, I appreciate that.
Thank
Any other questions, Judge Wallace or Judge Garrett?
I do not have any. Thank
All right,
you.
let's hear from the prosecutor and you'll have time for rebuttal, Ms. Schroen.
Good morning. May it please the court, Heather Bloomquist on behalf of the people. I apologize for my raspy voice. I am battling the illness that Judge Swartzel had mentioned is going around. Yes.
Thank you for staying away.
Yes, absolutely.
Don't take that the wrong way.
So just to address Judge Swartzel, it is my understanding, and I believe it's where I got these documents, was the PSI, was where the attached funeral expenses, the quote for the bench itself, as well as the depiction as a model. Now, if that's somehow inaccurate and the court doesn't have it in the court file, I guess I don't think I would necessarily want to be asking for remand, but I think that's where we would be if the defense is claiming that they need further facts as part of the record as it relates to this, as it relates to the contents of this memorial bench. But I think there is record evidence when you look at all of these documents together that there is not a headstone on the actual Sitzma Funeral Home bill, but then you have this write-up for the subsequent bench, which by its depiction appears to be a headstone or headstone-like memorial for the decedent in this case.
What about Ms. Schroen's argument that even if this is a headstone replacement, it's $20,000 and that's just an unreasonable amount for a headstone?
So I do disagree with that, Your Honor. I think when we look at the CVRA and the general restitution statute, it specifically articulates actual funeral costs or related expenses. And I think what was provided to the court here was an actual expense. This was something that, to my understanding, was in fact a bill, and it was paid, and it was found to be that. I don't think that this.
So there's a cemetery in my hometown that when you drive in, there is this statue of, I don't know if it's a Civil War general or something, but it's a pretty impressive statue. My guess is in today's dollars, that would probably cost $50,000. Is there no limiting principle on the statue? I mean, if you wanted to build, something that costs $75,000, I'm being a little ridiculous just to press you how far you're willing to go on this, but is there literally no limiting principle on quote unquote actual costs in your understanding?
Your Honor, I think that that's for the legislature to decide, and they decided it in the plain language that it's an actual cost. And so while it might be somewhat shocking to the conscience to hear about a statue being placed, that is allowable under the plain language of the statute, particularly when the statute and the CVRA are looked at through the lens of the Constitution, which is the crime victims' rights. Crime victims have a right to restitution. Additionally, that is what we are directed to enforce, which is full restitution being complete and maximal under Garrison from our Supreme Court. So while I understand it seems a little shocking if somebody were to place such a large, extravagant statute, but that would be for the legislature to decide. And the way it's written now, it is an actual cost.
Okay. And I just don't know, is there anything in the record to suggest that the roughly $20,000 of this bench was somehow, 2 or 3 standard deviations out of the normal bounds of what a headstone would cost?
There's nothing in the record. There is an itemized good faith estimate of internment costs that I provided as Appendix B, I believe, that does break it down, but that doesn't give us it in relation to what one might say is a standard marker or memorial.
Okay.
But
I'm
with
sorry, go
that,
ahead.
oh, I'm sorry, Your Honor.
No, please.
With that, it's the people's position that the trial court did not abuse its discretion. Both the CVRA and the statute support this, and it was a valid order of restitution.
Okay. Any questions, Judge Wallace, Judge Garrett?
Thank you.
No
All right.
questions. Thank you.
Thank you. Ms. Sharon, you have time for a brief rebuttal.
Sure. Thank you, Your Honor. Your Honor, obviously, Ms. Bloomquist and I have, I think, a difference of opinion as to what the bench is. If that is a critical fact for the court, which it may be, then maybe a remand, despite the fact that, I adore Ms. Bloomquist. I have no problem seeing her again. But if that's what the court needs in order to make an informed ruling, then maybe that's what should be done. When you look at the transcript of the sentencing hearing, all references to this matter, no one ever refers to it as a headstone. And I think that raises a real question of, is the photo that's been provided by the prosecution is in fact what $20,000 went to pay for. So, Your Honor, I guess I would sort of join Ms. Bloomquist that if the court feels that that finding of fact is important to the court's ruling, then perhaps a very narrow and brief remand would be appropriate, Your Honor.
Okay. All right. Thank you. That case is submitted. We appreciate the oral argument.
Thank you, Your Honor.
Moving on to the 18th matter for today, docket number 371416, Forbes v. Kinlan Construction, Inc. Ms. Forbes, you're up first.
May I be seated, Your Honor?
Oh, that's right. I'm sorry. Yes, I was told about. Yes, you may, please.
Thank you so much.
Yep. This is what happens when my judicial assistant is out of the office. I just, lose all understanding of details and have no memory. So, please put your name on the record.
My name is Tammy Forbes.
Okay. And I know that you are acting pro per, and you probably heard me at the beginning to say, this is not a time to go through everything in your brief. It's to highlight one or two things and then really to answer any questions that we may have. Sometimes we have questions. Sometimes the briefing is sufficient that we don't have questions. So just to give you kind of a background of how things go. So why don't you, hit one or two things that you want to highlight with us, and we'll go from there.
Thank you, Your Honor. Nothing much happened since our brief that was submitted, and I rely on that brief for your judgment and for consideration. And I'm here to answer the questions.
Okay.
Mainly, we are interested in those two questions that we
submitted.
We submitted already.
Yep. Okay. Thank you. We appreciate that. Let's hear from the other side. Make your appearance.
David Cleavorn, appearing on behalf of the defendant appellees. And again, I think I can rely on my brief for the most part. Just one quick point of emphasis that I think I broached in my brief, but I didn't really flesh out, is the issue of abandonment, because I think, frankly, given kind of the shift in goalposts after discovery and after my initial motion for summary disposition was filed, they focused entirely on this discrete shoulder injury that they want this court to analyze under Michigan's No Fault Act. And again, it's, kind of makes my job a little bit easier in that I was playing what I felt like was legal whack-a-mole at the trial court basis on trying to flesh out what exactly are you alleging constitutes negligence. And frankly, I think that what they've done now in the Court of Appeals on focusing solely on this left shoulder under the No Fault Act. I mean, that's abandoning and a complete shift in, you know, there's not really any mention of all of the allegations of negligence that were originally pled and litigated and fleshed out throughout discovery, whether that's the allegations of an implied breach of the implied warranty of habitability or implied supposed quid pro quo sexual harassment under housing, or again, some of the claims around loss of consortium or things like that. And so really, I think the only thing I'd like to emphasize is that, again, by focusing or shifting the goalposts entirely to a discrete shoulder injury under the No Fault Act that, again, was never pled, never alleged in discovery, really only popped up after a dispositive motion was filed, I think that there's been an abandonment of those other issues and claims. Otherwise, and again, I don't really want to waste my breath too much time on saying how the No Fault Act doesn't apply, because frankly, this isn't a car accident case. And even if it was, it would still require some sort of proximate cause, evidence of some sort of link of, you know, some sort of negligent conduct connected to a bodily injury. And again, there's just a lack of evidence in this case, and that's why summary disposition was properly granted. So I've got nothing else to emphasize for the panel today. Otherwise, I'd rely on my brief, and I'd be happy to answer any questions that the court might have of me.
Any questions? All right, thank you.
I do not have any questions.
Thank you very much, Your Honors.
Brief rebuttal to what Mr. Clavorin had to say.
Your Honor, I disagree completely. We didn't abandon anything. We just went through a summary disposition that was absolutely wrongly judged in our opinion. And because due to the fact that we could not respond to appropriately to defendant's summary disposition, and we had only 10 pages. So everything else was kind of, we need to pick what was the strongest thing that we had. And we decided to strengthen on the duty of the landlord to maintain premises and to avoid any injuries. So he breached everything that was there for us to live. And this was the strongest. I mean, he always insisted to be in my presence. And whereas he said, just give me some, at least hand me some tools, in a matter that he had no knowledge how to fix this thing. He wanted to repair this particular garage door that is very different and extremely heavy. And all of a sudden, whatever he expected from me to give him put me right in the injury threshold there. And then he dropped it on me, and I almost had a heart attack. And I had to go to the emergency room and spend there hours and hours for them checking everything. And since then, my shoulder, taking into consideration that in the meantime, I was also caring for my gravely ill husband together with my daughter, it aggravated it to such a degree that I could not function any longer. And I totally disagree about the standard of what is that?
If it's in your brief, that's, again,
Yeah, I mean, so absolutely nothing was, we just focused because of the definition of the summary disposition that states that a issue, genuine issue of material fact, is the one that would stop the summary disposition in order for a or for the court or the reasonable people to consider that this is a valid argument. And I was not given I was stopped at my explanation about the shoulder. The shoulder was given way before anything. That was one of the first issues that was put on display as far as my injuries were concerned. And then the no fault, it's again wrong. It is because what we researched, the moment that you have a statute and then it's not 100% specifying.
Well, and we understand, I think your argument is that it's part of the insurance chapter, as part of that code, and therefore it should apply beyond the vehicle context. So we understand the argument you made. And again, I want to reiterate that we really focus on the briefs at the Court of Appeals, and oral argument is really more just to flesh out one or two points or to answer any questions that we might have. So Judge Garrett or Judge Wallace?
No.
You have questions?
Thank you for appearing today, Ms. Forbes, but I do not have any questions for you.
Yeah, we appreciate you coming in. We appreciate you making your points. We appreciate the other side making its points. And like I said, what we really do is focus on the briefs and the record below. And so we will do that. And I anticipate we'll get an opinion out within the next few weeks. Okay?
I thank you so much.
Thank you, and hope your ankle feels better.
Not for a while.
Thank you. That case is submitted.
Thank you.
Thank you. Moving on to the 19th matter on our docket this month, docket number 372185, Call v. Caston. Sorry, I'm up here doing other things, highlighting and moving around. So, Mr. Gentry, go ahead and put your name on the record and you may proceed.
Kevin Gentry appearing on behalf of the defendant appellate. Your Honors, Justice Kavanaugh was right when she said that terms like this are commonplace in divorce and custody agreements. They happen all the time. They don't make it before this court too often because people follow them, but they do happen all the time. And the Kaloff, which this court dealt with on remand and then the Supreme Court split all over the place on going back up there, didn't have a square agreement like we have here.
So there's, in my opinion, just looking through this, and my opinion is not firm yet, just kind of noodling through this. The penultimate question of whether it was a motion for parenting time or a motion for a change in custody, in my opinion, is pretty material here. Because if it was for parenting time, then I think we go down the argument that you're making. If it was for a change of custody, I don't see how this provision applies, because as I read it, and I'm quoting here, at such time as defendant vacates his father's home and obtains his own living accommodations, the issue of parenting time shall be reviewed, the parties agreeing that defendant vacating his father's home constitutes a, quote, change of circumstances, close quote, and quote, proper cause, close quote, to revisit the issue of defendant's parenting time. So if the trial court was right that this was really a motion for change of custody, regardless of the label, then I don't see how this provision comes into play, because this is only a provision that deals with a revisitation of parenting time. Do you see where
I see exactly where you're going, Your Honor.
And do you agree or do you disagree with that reading?
I disagree with the reading. I don't disagree with Your Honor's rationale. In other words, this is a really poorly drafted motion. I'll be the first to give you that.
But I want to be clear. Do you disagree with the reading that says if this is a motion for parenting time, then we have to deal with this legal issue that you raised? If it's a motion for custody, change of custody, then we don't have to deal with this provision. Do you disagree with that bifurcation?
I do not, Your Honor.
Okay. So we really have to decide first, was this a motion for parenting time or a motion for custody, change of custody? And if we agree with you that it was really a motion for parenting time, then we get to this issue that you started off with. Is that a fair understanding?
That is correct, Your Honor, but I will add one thing.
Please.
If you disagree with me and you say this was a motion
still
for
win.
custody, I will be back in about 9 months because we'll file a motion for parenting time. And that's going to square up the issue one way or another. I mean, that may be what has to be done here. Unfortunately, these kids are not getting any younger. They're various sizes. But really, this issue has to be decided at some point because we know under Harvey and Korn, when a judge signs an order, at that time, they agree that it's in the child's best interest. Now, here we have the same trial court 5 years later. And if she doesn't think it's in the child's best interest, well, she's got to take evidence on the child's best interest.
But so why don't we before, and again, I think this is a very interesting question, and I think you're right. Courts have been dodging this thing left and right. But we do have to deal with the fact that, was this a motion for change of custody or a motion for parenting time? So why was the trial court wrong in concluding that this was a motion for change of custody?
I'm on page 52 of my appendix. Defendant's motion regarding parenting time and support. Relief requested. Revisit the issue of parenting time and award the parties approximately equal parenting time with 3 minor children. Now, I will give you that a change could, under Lieberman. Now, remember as well how much time my client had with the children every weekend and 1 day a week. So it's close. This may not even make Lieberman as far as a custody change, but it's certainly entitled, and the relief requested is parenting time. But he wants more parenting time.
Again, I mean, please address the trial court's ruling. The trial court concluded that this was a motion for change of custody. So why was the trial court wrong?
Because when we're looking at here, the trial court on page 25 of the transcript. So as to parenting time, I don't know. It sounds like he's some parenting time. He has some parenting time. The trial court initially says, okay, change of circumstance because change housing. Let's read this. I disagree with you people that can't just put in a shell review at this time because there's been a change of circumstance because you changed housing. If you put in every judgment, can you imagine what chaos that would cause? It's not necessarily up to parties. The parties should have, I don't know, they should have been clear as to what they were doing. What they understood.
You're reading and you're speaking very fast, and it's a little bit difficult to understand.
My apologies.
Just plain, just in your own words, why was the trial?
In my own words, on
excuse me. In your own words, just explain briefly why the trial court was wrong with the motion, considering, characterizing it as a motion for change of custody.
Because after she did that, she went to parenting time on page 25 of the transcript and denied it on that basis too.
Okay, so I mean, that may be belts and suspenders, but I think, if I recall correctly, the trial court did make a clear ruling that this was a motion for change of custody. And I believe it was based on the fact that it went from dad having, and I'm using rough numbers here, somewhere around 25-30% of the time with the children, up to close to 50%. I think it was, wanted something close to 50% or even above a little bit. Doesn't under Lieberman, how is that not a change of custody regardless of what the label of the motion was?
Because it was actually closer to 40 to 50. Lieberman says there has to be a significant amount. Lieberman, the threshold in Lieberman was it fell over the half. I'm not sure this falls over the half.
Okay.
And additionally, the trial court did.
So in your opinion, it's just the percentages. It's not as big of a gap or change as in Lieberman. Is that a fair summary?
Fair summary.
Okay.
And also on page 15, the trial court said exactly what Your Honor said, that this is about custody. But then on page 25, she says it's about parenting time. All over the map. This particular trial court, and I've appeared in front of this trial court, tends to talk at length. And sometimes, in this case, was talking a little bit in circles and made for a not clear holding. Quite frankly, Your Honors, if you find this is a custody motion and we deny it on that basis, I can't disagree with that because I could see where Your Honors could get there under Lieberman. And we'll take that custody ruling, we'll go back on parenting time, and we will be back in 9 months. So whichever way works, as a matter of judicial efficiency, I think it might be better to track it now.
I know you don't mean that as a threat, but it sounds like a threat.
No,
We'll be back.
No, it's just as a matter
It's a
of,
promise.
my point is, it's a matter of judicial efficiency.
Yeah.
And you're right, the courts have been dodging this case for years. They've got to get there somewhere because people do this all the time.
Yeah. Okay. No, that's helpful. And I mean, you know, we get your point that if it's not handled here, it'll be handled at some point in the future when there is a true parenting or a clean parenting time change request. Okay. Thank you.
Laurel Stewart Fink on behalf of the plaintiff appellee. I'll apologize for my voice. I'm not sick, but I just got over influenza and I'm not quite back to full hollering level.
Well, congratulations for getting over it. It's apparently it's not a fun
Wasn't fun.
flu season.
Not at all. You know, I submitted my brief, it looks like about 11 months ago, and I really didn't look at this case again until this week and in preparation for this morning. And it's interesting how stepping back and taking some time away from it can change your point of view. As I was reviewing this case, I was really stricken with the fact that this whole issue about, and I'm not saying it's not an important issue that courts need to resolve, but in the context of this case, this issue about whether the parties can define what constitutes a change of circumstance and whether or not that can be binding on the trial court is kind of a red herring. It's really an academic question here. And I don't think I really appreciated that initially. And the reason I say that is simply the context and the manner in which this case evolved. You know, the dad moved out of the grandfather's house almost immediately after the judgment. The parties entered into an agreement that should have been, but was not codified in a court order. For purposes of child support, they stipulated that this was the number of overnights. One child, I think 2 of the children were there 2 nights a week. One child was there 4 nights a week. And while it may not have been put into a court order, this is what was happening. The condition precedent had already been executed. It was kind of a moot issue. When this case came before the friend of the court referee and again in front of the judge, and I think that's what's bothering Your Honor, is that dad was asking for 50% of the parenting time, which would essentially become a change of custody. And he simply couldn't demonstrate a change of circumstance that would justify that kind of dramatic change in a parenting time schedule.
So do you believe that what father was asking for here would qualify under Lieberman as a motion for change of custody?
Absolutely.
Okay.
Absolutely. And I think when, we look at it from the point of view of the children, what had changed? I mean, this whole scholastic discussion over dad moving out of the house and timing of filing the motion from the point of view of the children has very little impact. From the point of view of the children, dad had been stable in his own home and there had been a parenting time schedule in place for close to 2 years, at least 18 months at the time the motion was filed. So I don't think that that's the issue before the court today. Not that it isn't an important issue, but the real issue here is, did the judge err in ruling that father failed to meet his burden of showing that there was a change of circumstance sufficient to modify custody in this case? And when a parent comes before the court having for 2 years exercised 2 or 3 overnights a week and is now asking for 50% of the parenting time, that's implicating the established custodial environment. That is a threshold that's controlled by Vadvarka, and father didn't meet it in this place, and the trial court was correct in that regard. And I would also like to say that it would be my hope that if the court affirms the lower court and dad files a motion to modify parenting time, that we'll get it resolved and you won't have to hear from us again.
So you're looking forward to coming back in 9 months, is what you're saying. Any questions, Judge Wallace, Judge Garrett? Okay.
No, thank you.
Thank you, Your Honors.
Mr. Gentry, you have time for a brief rebuttal.
Briefly, Your Honors. I appreciate Sister Counsel pointing out what was happening here as far as the children and the amount of parenting time for the 2 years in between, because quite frankly, it's on the edges of the record. But there was an agreement between the parties. And under Berger, an established custodial environment can happen regardless of a court order. In the absence of a court order, wherever the children are living, at least one child here was living mostly with dad. That opens up the whole can of worms that Lieberman wouldn't apply in one case, at least in one of these children. And it's a complex situation with the children.
Sure.
But based on Berger, at least one of the children was in an established custodial environment that wouldn't change under the motion. And that takes care of the Lieberman problem as to that child. I asked the court to look very carefully at where the children were and do the math, because math is different for each of the children. And I think that affects how globally this court can decide the case. Thank you.
Any questions, Judge Wallace or Judge Garrett? Okay, thank you.
No, thank you.
That case is submitted.
Thank you.
Moving on to the 20th matter for our case call this month, docket number 374950, Hamilton v. Cronbeck. I believe we have Mr. Gallant appearing remotely, and Mr. Gentry is here, and I believe you're representing the appellant. So do we have, okay, Mr. Gallant's here, so
Yes.
yeah, proceed.
Okay, Your Honors, there's three issues in this case I would like to briefly address, and they're all going to be brief because it is well briefed. The first question is, you had a trial friend of the court hearing. A friend of the court hearing made credibility assessments. Then the judge made opposite and would have granted my client's motion. Then the judge made opposite credibility assessments by watching the video. Is it live or is it Memorex? Watching a video is just as good as being there until the first time you've gone to a live sporting event versus watching on TV. Then you realize you missed stuff. And I think that we didn't have a deference at all. And there's a legitimate question here because this is happening more and more often. It's even happening, quite frankly, Your Honors, in this court, where this court is looking at, now that we have videos of every traffic stop, this court's looking at traffic stops and saying, do I agree with the district judge as to what happened here? How much deference do we give a trial court when we're looking at video? How much deference does the referee get when we're looking at video? I think that's a question worth answering. On the issue of legal custody under Daly, when the parties don't get along, page 84 of tab 8 of my appendix, the other side is admitting we can't co-parent. They can't. They really can't. And that's a problem under Daly. My client testified to it. He testified to it. Everybody agrees these two people cannot function. My client admitted before the opposing party admitted before the referee, calling my client all kinds of names. Said he never did in front of the children. He never did in front of the child, except that he admitted he never saw my client except with the child. It's really an ugly situation. And under Daly, when you've got that ugly a situation, expecting people to co-parent is not what should happen in the best interest of children. And finally, under parenting time, the trial court, for whatever reason, considered parenting time here to be a tag-along. It was a separate request. While my client was certainly asking for a change of custody, my client was also asking for supervised parenting time for the defendant. A little problem with substance abuse, missing drug tests, going to jail, operating while intoxicated.
Isn't he involved in a sobriety program? So at least as long as he's in that program, there's at least some hope, maybe assurance that he's sober?
There is. But that doesn't mean the trial court doesn't get the best interest on the question. The trial court didn't even get to the question. They said there's no change in circumstances under shade. The trial court never even got to that question. It's got to answer that question. Your Honor might be right. They might say that, okay, we've got this program and it's going to keep him sober and keep the child safe and keep him out of the driver's seat and those sorts of things. Maybe it does. But the trial court here applied just Vodvarka, never got to shade and never got to the parenting time question. So if that's the direction Your Honors are going, respectfully, you're jumping ahead of where the trial court got and not making the whole 12 factors that the trial court was supposed to do.
Okay.
Thank you, Your Honors.
All right, thank you.
Thank you.
Mr. Gallant?
Thank you, Your Honors. I also want to thank you for allowing me to appear via Zoom. While I don't have the flu, I have other medical issues that appreciate it to allow me to stay in my office and deal with this. In response to Mr. Gentry, it was respectfully arguments and the outline in his brief is excellent, I believe. But I think that with that first issue that he brought up with respect to the front of the court making a ruling and then the judge overruling it as to credibility. I think his argument is better suited for the legislature to change the statute, because the court is allowed to review de novo by looking at the video of the hearing. Now, 30 years ago, when I was a young lawyer coming up, I know that there were a lot of de novo hearings that were in person. And I don't know if the statute had changed at that point, but for judicial economy, now judges are reviewing this regularly. They're getting the credibility issues by looking at the testimony, not necessarily the person's body movements. That takes away what the not soul, but one of the main focuses of what a judicial officer does is define credibility by the person testifying. And whether that person is,
Mr. Gentry's point is well taken, that credibility is based a lot on what the testimony is, but a judge can definitely take into account body language and, maybe nervousness or whatever. I mean, the point is well taken that making credibility determinations over video is not the ideal situation.
I understood and I respectfully would agree with that, but it's also the standard that we're using right now with the review. So if the legislator wants to change it and say you have to have a new hearing because credibility is the focus, so be it. But that's not where we are today. And I think Judge Longsworth, by reviewing the transcript and seeing body language and seeing nervousness and seeing anxiety of testimony, was allowed to put that into context. And I think that even just reading a transcript, I think your honors could be able to do that. As opposed to the second issue for legal custody, I think this is simply that the plaintiff in this matter wanted to use the alcohol issues and the arrest issues and all the information that she found out and say that's enough to change the legal custody. The court was crystal clear in its opinion that under Simpson, that's simply not enough. And that's where the plaintiff just didn't meet her burden to show proper cause or change in circumstances to even get to the aspect of having the Vavarka best interest factors reviewed. So I would rely on the briefs in terms of the cited transcripts that the facts of this case are that plaintiff just didn't meet her burden of proof. And then going to the third issue of the parenting time, I believe the court spelled it out, and I know we spelled it out in our brief, that the plaintiff's initial motion had, although it cited items of custody and parenting time separately in its allegations, but in her wherefore paragraph, she asked for custody and then subsequently a change in parenting time. So I think the court is 100% reasonable in its decision that the request for parenting time was really if legal custody was changed. It was a kind of an add-on to where, and even if it wasn't, although the shade best interest factors would have been different than the Vadvarka ones for custody on the parenting time issue, the court made it clear in its motion for clarification that the plaintiff still didn't meet her burden. So they're trying to get a second bite of the apple because the parenting time standards would be lesser than the custody standards to get a best interest hearing. And the court said, nope, you didn't meet either burden, case over. So that's why we're here today. Thank you, Your Honors.
Judge Wallace, Judge Garrett.
Questions?
No.
Mr. Gentry, you have time for brief rebuttal.
Your Honor, if the wherefore paragraph controlled how we characterized the motion, you and I wouldn't have had that very interesting discussion 20 minutes ago.
Yeah.
And as to the legislature, the standard of deference given a judicial fact finder by appellate courts is determined in syncope for custody cases.
Well, I think there's case law that says that when you have video, our deference is less. It's not zero, but our deference is less.
Agreed. And as to the best interest for legal custody, the biggest problem happened, Your Honor, when my client discovered that the other side had parenting time while he was in jail. Dropped the kid off to the usual way, and as his mother ended up putting, I had grandparenting time for a while. That was a quote. That's not good. That's a sign of non-co-parenting here. When one party is not even present for custody of the child, but is maintaining legal custody. And
but isn't, I mean, it's an interesting issue when one of the parents goes to jail. We've been told, and I think the case law is very clear, that simply going to jail or prison is not sufficient grounds for termination of parental rights, for example. And if a parent does find themselves, unfortunately, having to be incarcerated for 6 months, for example. And if they make arrangements with a relative, like a mother, the grandmother here, to basically, be with the child during the parenting time, isn't that something we would want to encourage to kind of keep that, kind of parenting by proxy, relationship and bond in place?
It's an interesting thought, Your Honor, except that the custody arrangement, whatever it might be, has never been assessed as the child's best interests. That's probably a real issue because between the parents, the custody arrangement has been assessed. Between third party, it might be family member, it might be grandma might be very upstanding. It might be his stripper girlfriend. I don't know. And that's where the problem lies, in the fact that nobody knows this is happening. Everyone thinks, including the trial court, that the child court's doing parenting time with him and the child's parenting time somewhere else, which is certainly a problem if the child gets hurt, God forbid.
Right. Any other questions, Judge Garrett, Judge Wallace? All right.
No.
Thank you. Very much appreciate you coming in, Mr. Gentry. That case is submitted.
Thank you.
So we're moving on to the 11 o'clock. We're actually on time today. That's shocking. I think we're going to hear the next case and then take a brief break after that. So I'm going to call number 21 on our docket number 371663, Campbell v. State Farm Mutual Automobile Insurance Company. Do we have someone here for Neil Campbell? Sorry, do we have anybody here for State Farm? That's odd. Did anybody check in for that? It is 11 o'clock. Yeah, all these insurance companies, it gets very confusing. So Applee is here. Counsel for appellant is not. Let's do this. Would you mind sticking around for just a few more minutes? We'll take a break now, and then we'll come back at 11:15. We'll call the case then, and if other side has shown up, then we'll go ahead. Otherwise, you'll be able to make your argument, and we'll do it that way. Okay? All right. Thank you. Thank you for your patience.
Honorable Court of Appeals of the State of Michigan is now in session. Please sit.
All right. Well, we decided to give 5 extra minutes, and it does not appear that helped.
Judge, this is Stephanie in the clerk's office.
Yes.
I called his office, Mr. Sherbarth, and his assistant is going to call his cell phone. She thought he was supposed to be here today.
Okay. Okay. Thank you very much. It's always good when the Wizard of Oz of our IT department comes on and the voice from elsewhere. Well, I'm going to call the case. It's case number, it's item number 21, docket number 371663, Neil Campbell v. State Farm Mutual Automobile Insurance Company. It's 11:21. This is on our 11 o'clock docket. Counsel for appellants is endorsed. They're not here. Hopefully nothing has happened en route, but we're here. The Applee's attorneys are here, and so we're going to proceed. So I don't know, are both of you going to put your appearance on? Just one? Both?
I think we both are. I'm going to do most of the arguing, I think, on behalf of Mr. Campbell, but yes. I have a few things to say.
Okay. Please proceed.
Thank you. May it please the court, Josh McFarland appearing on behalf of plaintiff appellee Neil Campbell. Obviously, I want to just start off by saying, a few things about the facts.
We're well acquainted with the facts. I don't
Sure.
think we need to go over them.
Okay, absolutely. So, we have obviously this Love case, which came down not even a month ago. Clearly, I wish I could have been here over a month ago to argue this with a clean slate. But while I'm not going to obviously stand here and argue that you should issue a decision that's contrary necessarily to Love, I think we would obviously ask this panel to at least express some disagreement with that court's interpretation, especially as it relates to MCL 531.14 sub 6. We believe that that is an issue that was not really well looked at in Love. They spent a lot of time discussing 3107 and 3109, but they didn't spend a lot of time talking about the language and the construction of 3114 sub 6. It does appear that that case is probably going to be appealed to the Supreme Court. This one probably will as well, depending on what happens. But I would note that in Love, there is a slight difference of facts, which may be able to distinguish this case from that one. The policyholder and the driver of the motor vehicle in the Love case were not the same person. In that case, the policyholder was a Miss Rudolph, and the vehicle was being driven by a Miss Green. Miss Green was not a named excluded person for personal.
Why does that matter?
Yeah, so I think that matters because the court in Love, again, they didn't discuss a lot of 3114 sub 6, but they did seem to talk about the excluded person under 3114 sub 6, noting that Miss Green wasn't an excluded person. Miss Rudolph was. In this case, we have Miss Boswell, who was both the named insured and the named excluded person. And I think that matters. And if you look at the analysis itself, 3114 sub 6, this court's well aware of the language. I think it's poorly worded, but I think where the confusion comes from has to do with what the subject of that first sentence is. Are they talking about the applicable insurance policy, or are they talking about the person named in the policy? Because there's two interpretations that I think can be fairly made from reading that statute. The first way is, the person named in the policy, which is the subject of the sentence. And if that's the case, then it would read, the applicable policy is a policy for which the person named in the policy is elected to not maintain coverage for personal injury protection benefits under 3107D, or the person named in the policy is a person as to which an exclusion under 3109A2 applies. If either one of those are true, then the injured person, in this case the motorcyclist, claims benefits under other policies as if no such election.
So why is the very, that factual distinction? I'm having a difficult time figuring out why Love doesn't apply to both situations.
Well, in this case, Miss Boswell is a person named in the policy as to which an exclusion under 3109A2 applies. And if we read 3114 sub 6 with that interpretation, then the injured person, Mr. Campbell, shall claim benefits under other policies as if no such election has been made. So he moves down the order of priority, moving to his own motor vehicle.
But a fair
policies.
reading of Love seems to sweep a bit more broadly. I guess, you seem to be arguing that the grammar of the sentence supports your position. And you might be right. And frankly, when I read the sentence, I think I agree with you. I'm like, frankly, any exclusion means it's a plan that has an exclusion, therefore you move down. Maybe that's a simplistic reading, but that's my reading.
I don't think it's simplistic.
Love disagrees.
Yeah.
And Love doesn't seem to draw kind of that. It didn't seem to stop where you are asking it to stop. It seemed to sweep a bit more broadly. And I think at the end of the day, you're stuck with Love. And to your point, it's going to be argued before the Supreme Court.
Yes.
Well, you're stuck with Love, except for it's never actually going to apply anywhere, because you would actually have to have a situation where the person on the motorcycle gets hit maybe by their own car or by their spouse or a resident relative. In 25 years, I've literally never seen that.
I would like to see the
Yes.
statistics of that. I mean,
Yes.
you know, I don't
Yes.
know, maybe it happens. I've always thought, you know, when I'm backing up, I'm like, you know, I hope my kid's bike isn't back there or something.
Yeah.
I would assume that's how it would happen.
But it would have to be a motorcycle though, not a bike.
Yeah.
Correct. Yes. And you bring up a very good point, and that was actually going to be my
You don't even
next
need to
point.
go into that. I
Yeah.
mean,
So it just the love to say it doesn't make any sense because of that situation.
I think you have a very strong argument that love, there might be some problems with it.
Yeah.
But again, it is a published opinion of this court. We are bound by it. And, you know, I'm not sure that this is something that a conflict panel would be particular, because it's a fairly niche issue. And it might just be something that the Supreme Court has to take up and just deal with, even if it's by order. Because it seems like I don't know, it seems fairly clear cut to me, but.
I agree with you. And with over the last 5 or 6 years where this law has been in effect, that has been the interpretation, is my interpretation as well as yours. And I would also note, just briefly, that there actually is a case in the Court of Appeals that was argued just an hour earlier in Grand Rapids. The case is Maher, M-A-H-E-R. And I kind of went into this in my brief as well, depending on how this court was going to rule, as to whether or not the statute supports the idea that each policy under 3114 is an excess policy with respect to motorcyclists. So, I guess, as I mentioned, the court is taking that up.
In the Maher case?
In the Maher case, they're addressing that issue to decide once that first policy is exhausted. In this case, if the court rules Ms. Boswell's policy applies, $250,000 in allowable expenses. Once that is exhausted, which it most certainly will in this case, the medical bills are in the millions, then you move down to the next policy as an excess policy, with probably the exception that the insurer of last resort, the assigned claims plan, because it's a different setup in a different statute, would not be viewed as an excess.
I'll be honest. It's been an issue I've thought about, and I don't know that I've ever gotten a very satisfactory answer. Do you know why it's not just much more straightforward in terms of the motorcyclist is required, like a motor vehicle driver, to have proper insurance under the No Fault Act, and then that person's insurance on the motorcycle should actually cover that person's PIP coverage? What's the policy rationale, if you know?
Yeah, I think I do know. It was before I was born, but I spent a lot of time studying this and working with Wayne Miller in discussing this issue actually in depth. Probably because nobody at the time that the No Fault Act was created, where everybody had unlimited medical coverage on every policy that was issued, regardless of what they wanted, that was what they got. You would never be able to obtain a policy of no fault insurance on a motorcycle
Because they just get in too many accidents.
The premiums would be outrageous. Every case would be a catastrophic case, as is this.
Okay.
Yeah.
Well, it is worth noting that the motorcyclist does, if they own the motorcycle, they do have to have liability insurance on the bike.
That is
Otherwise,
correct.
They could be excluded from most of the potential coverage.
Yes. Yes.
Okay. Thank you.
Thank you.
Hi again, Judge. I think the security was going to pass you a note, but Mr. Sherbarth is in the gallery for Zoom if you want to allow him to.
Sure.
Okay, thank you.
Come on up. We'll take it a little out of order, but you'll have an opportunity to respond if he says anything that is so glaringly difficult that you need to respond.
He will probably just come up and say, see my supplemental authority.
He'll just say, see love.
Yeah.
Yeah.
So, Your Honors, thank you. Daniel Saylor appearing for the defendant Applee Auto Club. I guess I'll just take a couple points. I totally understand that love is on point in a published opinion, and I surmise that the panel probably has little appetite to come out and rule in our favor, saying that that case is wrong. Number one, you don't have that authority unless you find it distinguishable in some way. I think you actually could say that because important arguments were not raised in that case, and yet they are raised here, that could give you grounds to do that. I know that Judge Glacier, who sometimes felt, liberty to do certain things, did that in a case I have.
You want us to follow Judge Glacier's,
Well, it's practice, not necessarily in a particular holding.
Lisa's a good friend, but I think even she would
No,
say.
me too.
Yeah.
No, but anyway, I will just make this point, that the Love panel, for all the analysis they did, I don't think they mentioned ever or appreciated or noticed the fact that when a family or an individual policyholder decides to exercise an exclusion under 3109A2, and if everybody in her household is also covered by Blue Cross, and so they too exclude, by statute, their premiums for PIP have to be reduced 100%. And our policy paid zero, we received zero premiums for this coverage.
You can make all of the great arguments that you're making. Again, I think, you might be preaching to the choir.
Too bad you weren't here a month before, like he said.
Yeah, true.
And at the end of the day, it really is the Supreme Court who's going to have to decide this, because at the very least, I think, the fact that the Love opinion came out 3-0, that suggests, and, you can tell by some of our comments today, there would be disagreement on our court. And so a conflict panel may not actually clear up anything. We may, it may be very sharply divided conflict panel. And in that case, the Supreme Court would probably have to deal with it in any event.
Anyway, so true enough. I say that only because if another panel, and frankly, I know that the court seldom exercises the conflict panel option, but if your opinion could express doubt or, point these arguments that were not addressed, I'll just rely on my brief. I think that the points are made in good faith and are persuasive, to be honest. And if the Love panel did not appreciate those points, and it appears that they didn't, it could be pointed out in an opinion to show the Supreme Court that there's some disagreement here, even though you're following the Love opinion.
I think, maybe what you could seek and maybe ask for, and, I don't know that you even have to ask for, but in these situations, in my experience, maybe the best route is if you get a strong concurring opinion, because putting something in a footnote in a per curiam at the end can often get lost. A concurring opinion is something that can actually be written much stronger. Doesn't have to have three people to agree to it, and it's something that an applicant can point to when they go to the Supreme Court to show that there is a live controversy here.
Yeah.
I take it Mr. Sherbarth is, I hope security's not strip searching this guy or something.
Do we have a docket number for that Maher case? Feel free to chime in.
I've got it in my briefcase.
Okay.
I can get it while we wait for him to come up, perhaps. But
Mr. Sherbarth, I thought you were where are you at?
Good morning, Your Honors. This is Nathan Sherbarth on behalf of State Farm. I am remote. Mr. Freshour was supposed to appear this morning. We don't know what happened to him. I don't know if he got into an accident. We can't reach him.
Okay.
He was supposed to be in person.
Hopefully Mr. Freshour is okay, and we hope he's okay. From your perspective, Mr. Sherbarth, I don't know that you need to say anything other than see love.
It's right, Your Honor. I'm not sure I can really add much. It sounds like we have a personal disagreement about the decision in Love, but as I would say, see Love. It's a 3-0 opinion. If the Supreme Court wants to take this up on Love or elsewhere, that's certainly their prerogative. But we think it's clear, and I appreciate your entertaining my appearing last minute like this.
Well, pun intended, but Love has not gotten much love today. But we'll see how things shake out. I mean, I think it's pretty clear to say that we are bound by love. And the question is, how much of a message are you going to be able to get from this panel? But at the end of the day, I think this is going to probably be handled at the 6th floor rather than the 3rd floor or 2nd floor. So anything else? Any questions, Judges Garrett or Wallace, that you want to explore?
No.
Separate from our love case, I want to address the Maher issue just very briefly. I want to say that the issue of whether, for instance, if Auto Club has 250,000 obligation first priority, the question then would be whether the motorcyclist's own policy kicks in and operates as an excess policy, or it's an either or situation and not an excess policy. That issue was not decided below because the court didn't need to get there. So it's not before the court.
We won't say anything to screw up your position.
Well, thank you, because I have that issue next month. Exactly. And
we will.
I'm hoping the Maher case holds off so that I have
our motto is do no harm. So we will not impinge your position
Did you want
in an issue not related to this case.
So what I'd like you to do, if you wouldn't mind, is after we submit this case, if you could just pass a note to the bailiff about the docket number, and then he'll give it to me. That would be great.
Certainly. I'll look it up right now.
And, and Mr. Sherbeth, just so we're clear about what I'm talking about, he's going to give me the docket number for the Maher case, unless you happen to have it handy.
I do not have it handy, but I would concur with Mr. Saylor that that's not before this court, and I appreciate the court's comments on that in that regard.
Thank you.
All right, thank you.
Thank
that
you,
case is
appreciate it.
submitted. Mr. Sherbert, thank you for appearing kind of on an emergency notice. We very much appreciate it.
Thank you.
And we are hoping that Mr. Freshore is okay.
Certainly.
Case is submitted.
Thank you.
Number 22 on our docket, there was a motion to dismiss that was filed either yesterday or this morning. The panel has voted to grant that motion to dismiss. I don't know when the order is going to get out, if it's already been entered, but if it hasn't, for whoever's watching this on YouTube, case number 373591 is going to be dismissed. So moving on to the next set of cases, it's a consolidated matter. 3 cases. Docket numbers 372975, docket number 372990, and docket number 373877. It involves the University of Michigan Regents and Caden Knight on one side versus Auto Insurance Company on the other side. And we have one oral argument or a remote oral argument, I believe. Mr. Nachzel.
Yeah, I'm here. I'm an appellee though.
We can't see you. Can you turn your camera on?
It's on. Can you turn it off?
Have IT help us out. You go ahead and sit down.
Mr. Okay.
There we go.
Yeah, I believe your shutter might be on your camera. Oh, you got it.
Yep.
Is there? Okay. Mr. How do you say your last name?
Knock Hazel. Two words.
Hazel?
Knock and then Hazel. Yeah.
Not Hazel. Okay. All right. So who do we have for the appellant side?
State Farm. So appellant from Washtenaw Circuit Court's order appellee as to.
There's a lot there. Who else? State Farm and Geico on that side. Okay. Mr. Knoxell, who do you represent?
I represent plaintiff appellee, Kate Knight.
All right. So let's hear from appellants. And how are we? Go ahead. No, go ahead.
So, obviously, Your Honors, we arguing this issue.
Yep.
We are appellant in the Wayne County circuit court case. We are appellee in the Washington. Because I'm kind of arguing it by myself, I mean, I can go after them.
At the end of the day, we have one side arguing that this gentleman is an independent contractor, one side arguing that he's an employee, correct? All right. Do we need to have, so we've got three attorneys arguing that he's what, an independent contractor or an employee? Employee. And all three of you are arguing an employee. Nakazel, are you?
Yes. Yeah, and I'm happy to let the other appellant or appellee counsels go first and just chime in at the end if you need anything.
Unless there's something absolutely critical that Geico believes State Farm can't handle, I think we need one person arguing employee and one person arguing independent contractor. Is that fair? Perfect. All right. State Farm, you have the floor.
Sorry, I went to the appellant side because ours was first, so I just.
That's fine.
So this is
Please put your name on the record.
I'm sorry, Lauren Hagerman on behalf of State Farm.
Thank you.
Again, that's appellant in the Washtenaw matter and appellee in the Wayne matter.
Okay.
So these are competing motions, summary disposition orders. Washtenaw says he's an independent contractor. Wayne says he's an employee. So team employee, State Farm, injured person, Caden Knight, Geico, Wayne County, and then you've got Washtenaw and auto owners saying that's a matter of law. No, we disagree. He's an independent contractor.
So we have this multi-factored test or standard that we look to. Why, I guess, regardless of, let's say that there's 5 factors. I'm just, 5 factors. 3 are on your side, 2 are on the other, or vice versa. My first question is, does this go back as a question of fact in both cases? Or are both sides going to essentially argue we win as a matter of law, it doesn't have to go back?
I think you'll hear from both sides that it's a matter of, that we win as a matter of law. It doesn't have to go back. I know we have competing rulings and we've got a fact-heavy framework, but the facts underlying that analysis are not in dispute. So we're really looking at how does this legal framework, how do these factors apply?
All right, so why is it Mr. Knight? Why is Mr. Knight an employee?
So, Your Honor, everything points to employee. First of all, there's 2 kind of tests at play here. There's this traditional 4-part framework that we've referred to as the Adanalek test. It predates that. This is an independent, the economic reality test. And then there's this McKissick analysis, which sets forth these additional 8 factors. And I think that it's just important to highlight that before I dive into that, because those factors come from a workers' compensation context. And in 2020 in Duckworth versus Cherokee, this court looked at all of that and said, what are we going to do with these frameworks in the no-fault context? And the court said, we're going to apply the 4-part framework and we're going to adopt this McKissick framework. So we've got 4 original factors and then 8 additional factors. And we think all of them are relevant under the context of no-fault priority.
Well, and if I recall correctly, it would be fair to say that some of the 8 could be subsumed under one or more of the original 4. They're not, the Venn diagrams have considerable overlap between the 4 and the 8.
Yes, I think the 4 original factors fall neatly into these 8 McKissick factors. And the reason that I think that that's important is if you look at the McKissick opinion, this 4-factor framework existed then, and the court said, we get that this is out there, but it's too conclusory and it's not giving guidance to the bench and the bar. And we want to look at all the case law and figure out what these factors are and give some guidance here. And so I think what that does is prevents this from becoming too much of a gut check, right? It's a totality of the circumstances, but we still need a framework and we still need guidance. That's what the McKissick analysis did. And then this court adopted that in the Duckworth case.
I'm guessing you're going to tell me, though, or you're going to tell this court that you win under either.
Of course, Your Honor.
All right,
And I think
so
we
why
do-
do you win under either?
So I think the running theme is control and, an independent contractor, right, is you hire someone to paint your house. They get paid for the job. This person is a painter. They bring their own equipment. They can subcontract the job if they want. If you bail at the last minute, they can sue you for breach of contract for not fulfilling your job. An employee is someone who's under the control of their employer. They've got a set wage. In this case, we've got a set hourly wage, right? He's making $18 an hour for bearer fare. He's making $10 an hour when he drives. He's being told what to do by the company when he shows up for his shifts. They're telling him what work he's going to do
Well,
that
but
day.
let's not gloss over the reality, which is when we say the company, it's his grandma.
Sure.
I mean, is it problematic? Because a lot of the case law that I've looked at, it involves the truck driving industry, and whether somebody's an independent contractor or not, that gets very complicated. I didn't see a lot of cases where we have basically a family business and you have a rather loose, maybe unofficial relationship there. What do we do when it's a family business like this, when there's not a lot of formality in terms of the relationship?
So, Your Honor, I think that goes back to why that framework is useful, because it's not, although the family business isn't formal, when we go through those McKissick factors and that framework that's in there, they're looking at other pieces of the puzzle. They're looking at, how was he paid? Was he controlled by the employer? Did he bring his own equipment? Could he be terminated at will, or was there liability for canceling the job, going back to the painter example? So I think the short answer to that is, you deal with it by looking at the reality of this relationship. And I think it's certainly something you could keep in mind, that it's informal, but that doesn't undermine the economic reality under these frameworks, that he's getting paid this hourly wage. He's showing up when they tell him to show up. He had some latitude in his scheduling, but he didn't just come and go as he pleased like your painter might.
What do we do? I think at one point he asserted that he was an independent contractor. And if I also recall correctly, he didn't get a W-2.
Correct.
So what do we do with those two facts?
So his assertion that he was an independent contractor in his application for PIP benefits, number one, I think it was in Duckworth, this court mentioned that alone, self-identification, is not dispositive to the analysis. We want to keep an eye on the totality of the circumstances. And number two, if we're going to consider his self-identification, we should also consider the fact that in this litigation, he's taken the position that he's an employee. So I guess at a minimum, we're calling that piece of it a question of fact, but he has taken the position now that he was an employee, as did the employer, said, we regard him as an employee. The court asked another part of that question, and it's escaping me. Can you remind me what the other piece of your question was?
No, you answered it.
I'm sorry. Okay. So I think when you look at all this together, I think the informality of the family relationship doesn't take away these pieces of the puzzle that are there by the fact that this is someone who looks like his employer. And when this accident happens, he's driving a company cargo van that's insured to the company for company business. He's coming from a gymnastics meet where he's selling apparel. This is part and parcel of this company's business, right? He's clearly in the scope of his employment.
It's the main part of their business, right? I mean, this is what they do. They go to various competitions and sell merchandise.
Yes, absolutely. When he's not doing this meet attendance, he's still working 35 to 60 hours a week. So I think auto owners makes a lot of the fact that he didn't like going to the meets and doing this piece of the job, but he was still there, 35 hours by most standards is full time, up to 60 hours a week. And he's doing things that are still pertinent to the company's functioning, like designing the gymnastics apparel, handling the merchandise in the warehouse. And he's doing some odds and ends too, but again, those are being dictated to him by the company. He's being told what to do. This is not someone whose day job is, oh, I'm a driver and let me offer you my services to go to meets on a job by job basis, and I'll take a commission and then maybe next weekend I'll work for somebody else. This is not that. This is an employee who's doing what his employer told him to do. And again, kind of going back to those 8 McKissick factors, that's what they're looking at. And kind of backing up again to the fact that these factors kind of prevent it from becoming a gut check. I think if you look at the Washtenaw court's ruling, the judge makes this comment of, oh, this just reminds me of my grandson mowing the lawn. And I think this is the same thing. And that's not an employee. And that gets to that sticky piece of the informality. It's a family relationship. And I think that highlights why it's important to keep in mind all of those factors under both analyses, that we've got a framework to follow here beyond just grandson working for grandmother.
Well, and I'll ask this of opposing counsel too, but is there any question that we have to fit this into one of two categories? Either Mr. Knight was an employee or he was an independent contractor. We don't have some third category of family business, quasi-employee, quasi-independent contractor, something. I mean, we literally have to determine he's either an employee or he's an independent contractor, and we don't have a third option. Is that fair?
Correct, Your Honor, that I'm aware of, or that I've thought to argue. I mean, when the court looks at this, and even in the no-fault context, you look at, the Duckworth case, it's which one were they, so that we can decide under 3114 which insurer is in priority. So that's really what we're getting at here. And looking back at, again, this is a no-fault case. We're talking about priority. And one of the McKissick factors is, what is the point of the statute? And in 3114, we have a legislature who said, when you've got an employee and an employer-owned vehicle, we want to shift the burden of that liability to the employer to pay for that premium and the insurer of the employer's vehicle. Auto owners knows it's insuring this loss. It knows it's insuring a business vehicle. We got personal insurers on the other hand, State Farm and Geico. They don't know that they're insuring this individual to drive in a cargo van across the country and a van full of gymnastics apparel. So I think that gets to, the point of the statute is, why do we have this exception to priority? This is exactly why. And this is the situation that the legislature was trying to address.
Any additional questions?
No.
Judge Garrett? Okay.
No questions. Thank you.
I know it's dicey because we've got different roles here, but if I could just take a couple of minutes for rebuttal. Thanks.
Thank you, Your Honors.
No, go ahead. Everybody, yep.
Stephen Fucher on behalf of homeowners. I want to hit a few points, Your Honor. I think the question is whether there could be any additional category, whether it's independent contractor, employee, or something else. And I believe, Your Honor, that the case in Salina addressed that, especially in the concurrence. The court does look at employee versus independent contractor, but the court should also look at whether the person is self-employed. And that could probably be a subcategory of independent contractor.
It's almost, I think maybe the best way to think about it is either employee or something else.
Yeah.
And that something else could be independent contractor, self-employed, whatever. But it's either employee or
something else. Yeah, I totally agree.
Okay.
So a few points, Your Honor. Your first question was why an employee, at least to opposing counsel. So the question to me is, why an independent contractor? Well, let me go through the list. No application for employment, no employee handbook, paid by cash, no W-2, no 1099, no set schedule. Ms. Cook testified that he would come and go as he pleased. He could say no to a job. He could say yes to a job. He had that independence. He had a second job at JJ Tree Trimming. He also indicated on his application, independent contractor. In addition to that, Your Honor, when the accident occurred, he called his mother. He didn't call his grandmother. The AAA card that he used was his grandmother's personal card, was not the business account.
But wouldn't all of this be fairly routine or expected in a family business, where even if somebody is an employee, they might want to call their mom before they call their grandma because they don't want to get in trouble with their grandma. I mean, there's lots of family dynamics that would be intermingled, but that doesn't necessarily make the person independent contractor.
Well, and if you permit me, Your Honor, I can bring in my own personal experience. I worked for a furniture company that was owned by my brother. I was a interior designer in my first part of my career and a furniture salesman. I also worked as a truck driver. I also delivered furniture.
Well, you got all the relevant experience for this kind of case.
Yes. I was W-2. I clocked in. My brother always knew where I was at. I was a salesperson. I received commission. They took taxes. They provided me insurance. My father worked there. I worked there. My brother worked there, and my other brother worked there. Also, my sister-in-law worked there. When I say it was family business, it's a family business, but everything was formally done. There was protections. I was entitled to sick leave and vacation leave.
So it's fair to say that the formalities of employment weren't necessarily followed here.
Very true.
They weren't.
The other,
But
oh, go
what
ahead.
about a critical fact that he was involved in activity that was central to this company? It wasn't mowing the lawn. It was doing exactly what this company does.
Sure. So the fourth factor that's talked about, which specifically is that whether there's an integral component of what they're doing, which is, I always butcher it. One of my colleagues here, I keep saying analytic, but it's a danalic. But anyways, the fourth factor speaks to that, but it also goes into what is the degree of their involvement. What I mean by that is, are they necessary for that position?
See, I think there's case law that has made it very clear that whether the employee or whether the person is critical to that doesn't matter. Is the activity critical to the company? And here it cannot be disputed that this was critical to the company. This is what the company did.
Yes, but at the same time, Your Honor, when asked Ms. Cook, she said that he did it very infrequently.
So what?
Well, that's where it comes to employee versus independent contractor. And on top of that, I do believe that Farm Bureau v. Westfield, as well as the more recent case in 2020, also talked about, and also Analytic, and Adenalic also talked about that the means and the frequency of their job and employment is a relevant factor for that subsection 4. So I do think, Your Honor, I do posit that the fact that he was not doing it regularly, and the fact that he could come and go is a necessary interpretation, or at least something that you should look at in terms of the fourth provision.
Is there something to opposing counsel's point at the end that, I mean, auto owners, I got that right. You're auto owners, right?
Yeah.
Yeah.
Yes.
Auto owners, you insured this company vehicle. This company vehicle was used on company time, and this company vehicle was used for an integral part of what this company does.
Sure.
Doesn't it just, as a matter of common sense, suggest that then auto owners, which I assume you gave a rate that took into account what this vehicle is going to be used for, doesn't it just make as a matter of common sense that your company should pay for it versus State Farm or Geico, who apparently are getting pulled in because Mr. Knight lived with someone who had State Farm or Geico?
Well, typically in commercial automobile policies, the drivers will be notified, at least employees will be listed on the policy. In other words, they will be named as a permitted driver. I've dealt with a lot of.
That's not necessary.
Not necessary, but generally the case. And in this particular case, he was never noted as a permitted driver.
Right.
So that's not something that the auto owners or my client would have been able to increase a premium for without knowing that somebody else would be specifically using it, especially as to him being so irregularly driving as the way he was. So what you're positing, Your Honor, is that because there's a possibility that someone else could use it, therefore there should be a higher premium. Well, that would be the case for
It's just the fact that your company insured this company vehicle.
Yes.
For the types of activities that was what this company vehicle was being used for, when through no fault of Mr. Knight's, it seems, he got sideswiped by a driver on the highway.
Well, yeah, and I think that goes beyond that, Your Honor. Let me answer this. The reason why is the same reason why we look at resident relatives. The same reason is why we look at other aspects as whether which insurance policy is priority. And so when you're saying, okay, well, another driver could drive this vehicle and there's a possibility that could happen. Well, the same case is if my daughter takes my car, but she's not living with me. Technically she be coming under my policy? Yes, but not under the law. Not as a resident relative. She's not living with me. So what you're positing, Your Honor, is that because we insured the vehicle, anybody that uses it for the purposes of the business will therefore be considered insured for the purpose of the policy. Well, that would go against statute because the statute also speaks as to the person need to be employee under subsection 3.
Okay.
So And that's where I believe, Your Honor, Selena talks about, and I think Selena is important to the perspective that you need to look at what the statute says. Yes, it's important. There's a policy in place that commercial automobile insurers need to be able to take up insurance coverage and extend it to people that are driving their trucks. But the statute also speaks as to whether the person's an employee.
Well, how many employees did the company have?
According to Ms. Cook, 5 to 10 employees.
How many of them were listed as named on how many were named on the policy?
I'd have to verify, but I believe 1 or 2, if I'm correct. I believe, and I can clarify that, Your Honor, I can even submit a supplemental brief with it if you'd like it, Your Honor, but I believe that one of his relatives, it could have been Hunter, his brother, or his cousin, or I think he was a cousin, Dorian, may have been on the policy itself as well. And they were paid a salary, whereas Mr. Knight was not.
So you got between 3 and 10 employees that aren't named.
Give or take. There are, I would actually posit that a lot of them are independent contractors. I wouldn't necessarily qualify them as employees, but I'd say there's a stronger case that Hunter and Dorian are employees by virtue of their relationship and by virtue of the fact that they're receiving a salary, which is much different than, and I would
But
also.
you can have part-time employees. I mean,
Of course.
the fact that Mr. Knight did not work as regularly as maybe one of his brothers or something, that's not dispositive.
No, it's not dispositive. I would agree with that, Your Honor. But the fact is, when Ms. Cook testified, when asked how many hours did he work before the accident, she said, "Oh, I have no idea, not regularly." How much did you pay him? "Oh, I didn't know." "Did he ever submit pay checks?" Yeah, he did. I mean, hourly statements. "Yeah, but his via text is very informal." The whole relationship was informal. And so if we were to adopt that this is an employee relationship, we would necessarily have to adopt that every informal familiar relationship would turn that person into an employee.
I think that's going a little far. I
Yeah,
mean,
that's a bit of a stretch.
Well, no, what I say by that.
The facts of this case don't matter. We'll just announce that as a rule of law, right?
No, what I'm trying to say, Your Honor, is that when you have an informality like this, it doesn't automatically, just by virtue of them being family members or by virtue of them being close, turn it into an employee relationship because they didn't dot the I's or cross the T's. I agree with counsel. You have to look at the specific facts, is what I meant to say. And really, with Duckworth, Your Honor, there's that position as whether McKissick should apply or whether Danilic should apply, the economic reality test. I would point you to Duckworth and the fact that the concurrence, I think Judge Riordan hit the nail on the head, where he says, "I agree with the outcome. However, I would have stopped with the economic reality test because the court in Duckworth, the majority referred to ASCU, and ASCU, which is a Supreme Court ruling, I believe from 1975, talked about the McKissick rules."
well, let me ask you the question that I asked opposing counsel.
Sure.
I mean, we can make these distinctions between
Yes.
4 and 8. Do you win regardless of which test we decide to apply?
Yeah, I would argue, but
It's an interesting academic issue that comes into play when whether you adopt the 4 versus 8 is outcome determinative. But I think both sides have said it's not outcome determinative. You both think you win, regardless of which test you apply.
yeah, but I would say under McKissick, like factor 1, I think goes against us. I'm not going to say here and say, "Oh, every factor goes our way." I disagree with that. I have to admit when factors don't go our way on McKissick. And I believe the first factor is what liability incur in the event of termination. Well, the business would not have any liability in terms of in the event of termination.
So it's a closer call. Is it fair to say under McKissick that
it would probably be a closer call. I still think that there's more factors that benefit us, but I definitely, I would never say here up here, Your Honor, and say, "Oh, it's going to be 100% supportive," when it's not. So I have to acknowledge the bad facts. And Your Honor, the bad facts for me, and I'll be honest, is the fact that he works 40 to 60 hours according to what he says. But then the grandmother says he worked very irregularly and he would stop working for weeks. She testified. So there are unfavorable facts, I think, on both sides. Really is applying the test and which test to apply and whether those particular factors are satisfied by each.
Do you agree with opposing counsel that the evidence isn't really at issue, and we should be able to make a ruling as a matter of law, regardless, whether it's employee or independent contractor, versus saying that there's a genuine material fact and send it back.
Yeah, I would agree with counsel because the testimony is clear as to what they say.
Okay.
There is no employment file. There's no extrinsic express evidence outside really the testimony and the application and other things that have been
There's
said.
nothing for a jury to do here.
Exactly. And,
Okay.
we'd be asking the jury to assume the role of a judge and make a ruling as a matter of law, which I think would be inappropriate in this particular circumstance.
Okay.
But I understand, Your Honor. And I think the other thing I would leave this court with is that really, when it comes down to it, there was a case, People v. Young, that we cited to, where it says if opinions conflict post November 1st of 1990, it should go with the first issuing published opinion. In that case, would be I can't say it, a Danilic. Help me out here, guys. A Danilic. And that is supported the economic reality test.
Okay.
And so what we're saying as a whole, it points to an employee, not an employee relationship, but an independent contractor relationship.
Okay.
Is there any other question that I can address or answer anyway?
Well, are you saying that Duckworth didn't follow Atlantic because it suggests in the wording of the opinion that it did?
No, it went beyond it. It went beyond it and applied the opinion, or at least the factors, the 8 factors that we've been discussing under McKissick. I apologize, Your Honor.
Oh, right.
So what I was trying to say is if you look at the Duckworth opinion, it talks about.
You're saying Judge Reardon's concurrence in that case was correct in that
on point.
The adoption of McKissick factors was probably dicta.
It was dicta. Exactly. And he actually refers it to as dicta because in Askew, if you look at footnote 7.
And we'll just have to look at it and see if we agree or not, because
yeah.
I mean, I've written concurring opinions. I wish those controlled future outcomes, but that doesn't always happen that way.
No,
so.
And I would just point Your Honors to footnote 7 of Askew, where it talks about McKissick, and it says that McKissick provides a great historical context as to the economic reality test and its usage. But then right under that says we're going to apply the economic reality test.
Okay.
And that's what I'm saying is Duckworth went away from that and interpreted, extrapolated that Askew was saying, use the McKissick test, which it wasn't actually saying. That's all I'm saying.
All right. Thank you. Anything else? All right. Thank you.
Thank you. Thank you, Your Honors.
You have time for a brief rebuttal.
I'll keep it brief, Your Honor. First of all, Duckworth 2020 published opinion binds this court, not the concurrence, as you said. And you'll look at it like you said, but the court says we're deciding which factors apply. We're looking at these tests.
Why isn't Atlantic the first case in, as counsel argues?
I'm sorry, Your Honor?
Why isn't Atlantic the first case in, as counsel just argued?
Well, I think they're consistent. Duckworth doesn't say disregard the Danilic, factors. They say we need to look at both, and they acknowledge the overlap between the factors that we talked about earlier. And again, I do think we went under both.
And Atlantic never even mentions McKissick, right?
No, I don't believe it does off the top of my head. But why are those McKissick factors helpful here? Because they tighten it up, because otherwise we're looking at things that are really out of left field. It was informal. He didn't submit a job application. I used to work for my grandma's company and I never submitted a job application, and I don't think I was an employee either. It becomes subjective. We still need some framework, and McKissick gives us guidance on that beyond just these 4 kind of broader factors that were the original factors. And it's interesting.
Well, regardless of which test we think it applies, at the end of the day, the ultimate test, I think, is totality of the circumstances.
Yes, sir.
Which I don't know what that means most of the time, but I gather it means you basically just consider everything.
Sure.
So,
and I think the more guidance, the better on that, as the McKissick court acknowledged. And it's interesting, counsel mentioned factor 1 of McKissick is whether he could be terminated at will, whether there was liability if the employer terminated him, excuse me, that overlaps with one of the Danilic factors, right, to hire, fire, and discipline. And that weighs in favor of employment here, right? He's serving at the pleasure of his grandmother at an agreed upon hourly rate. She testifies she can fire him. She testifies she can discipline him. It didn't come up that she had to, but she could if she needed to. And he's serving at her pleasure. One thing I just wanted to, I guess, correct, there was a comment that Ms. Cook testified that Caden Knight would sometimes go weeks without working, that it was sporadic. If you look at that testimony in context, it's around pages 19 to 20 of her deposition. She's talking in the present tense there. Counsel then clarifies, are we talking about time of accident or are we talking about now? She says, I'm talking about now. So she did not testify that at the time of the accident, he would go weeks without working. She said it varied, but she said she would discuss the schedule with him in advance. He said the same thing. He did not come and go as he pleased like an independent contractor. He came when they agreed that he would be scheduled to work. And, I think looking at those things, again, just kind of getting back to this point, we have to look at those details, right? That, he's doing what they say. He's doing it for an indefinite time period. And when we don't do that and we just look at, okay, it was informal. Okay, he was a family member. Where do we go in future cases? I think that's the line we have to walk when we're talking about a totality of the circumstances test is we've got to find a way to make this case by case and make it workable. And if we're just looking at everything, did he submit an application? Was there a W-2? Which, by the way, nobody got W-2s, even the people that auto owners has said were employees. So that doesn't cut in anyone's favor in this case. I think it's too subjective at that point. We need to tighten this up. We've got authority to do that in Duckworth. And when you go through all those factors, you get employment and you get them under the 4 Danilic factors as well.
Okay, thank you.
Thanks, Your Honor.
Thank you.
Just because I'm also opponent, can I just get literally 15 seconds? I'm just going to say a couple things. That's it. I do appreciate that. I just want to clarify, when I said that number 1 in McKissick doesn't favor us, that actually deals with liability, whereas.
Are you saying something new or are you just going to be reply, is this a sir reply?
This is a sir reply.
You have 15 seconds then, because I don't typically allow sir replies.
Okay, I apologize, Your Honor. Thank you. What she indicated, that's number 1 under a Danilic. That's actually 1 is number 7 under McKissick. Number 1 at McKissick is new because it deals with liability if someone was to get fired for that business. So unfortunately, it's different.
Okay.
And then obviously the disagreement as to the testimony, the transcripts speak for themselves. Yep. I'll leave it at that. Thank you, Your Honor. I do appreciate your time and thank you for allowing me to do that.
Sure. No problem. Thank you. Those 3 matters are submitted.
Thank you, Your Honor. Thank you, Your Honor. You have a good day.
Thank you. You too. Looks like someone had some assistance today.
Yes, my daughter, she's 7 and she really wanted to come.
And what's your name? Sophie? Do you want to be a lawyer someday? Maybe? Maybe. Well, hopefully this hasn't dissuaded you. We'll have a safe trip home.
Thank you for your kindness.
Thank you.
Yep. Calling the 25th matter on our docket number 374820, In re MSL minor. Please.
Good morning, Charles Widmeyer on behalf of the appellant. This is a step-parent adoption case. Step-parent adoption cases require the termination of a parental right. I represent the mother of the minor child who is 11 years old. This is the second time that this case has been to the Court of Appeals. The first time was after the trial court granted summary disposition in favor of the father on one of the 2 issues that the court has to address. And that is whether or not the father, having the ability to do so, provided regular and substantial support.
And I think in the first case, they found regular, but the question was whether it was substantial. And that's why it got sent back down, correct?
It's correct. And I think additionally that there was really never a determination as to the ability to pay.
Well, I mean, if I recall correctly, the trial court focused on remand, on whether there was substantial support. And so why was the trial court wrong, do you believe?
You mean after remand?
Yeah, because we're not revisiting what happened the first time it was up.
That's correct. Because the court didn't find that there was substantial support. I'm sorry. The court should not have found that there was substantial support. And if you give me a second so I can explain a little bit. When you have a issue with respect to support, the trial court has one of two things that it has to decide depending on what a support order says, if any. Where there is a support order that requires the payment of cash support, the trial court's sole issue is whether or not the parent substantially complied with that support order. And the reason is that a party's ability to pay and what is substantial is baked into the child support formula.
So are you suggesting that any deviation from a child support order would mean that the parent was not providing substantial support? So let's just say the child support order said $100 a month and the parent was paying $95. Do you think that would undermine the argument for substantial support?
No.
Okay.
I think if you paid 95 out of the 100, that's substantial. And I think trial court would be well within its discretion to find so. But that doesn't apply in our case because we have a support order that says $0 are to be paid. When a trial court is faced with a support order that says $0, or if there is no support order at all, or if there is a support order that reserves child support, that's where the trial court has to make that determination as to the ability to pay, and then whether or not they have paid substantial support. So on the one hand, you have guidelines when there is a dollar amount. Otherwise, you have to make this determination. This goes back to the divorce case in Wayne County, and just so the court knows that this termination case is out of Livingston County. But the father was incarcerated in prison when the divorce matter was being heard in Wayne County Circuit Court. And on a day of a settlement conference or a pretrial, whatever it was, my client provided a proposed judgment of divorce with a proposed child support order that provided for $200 and some odd of child support monthly. The father appeared via television or whatever from a prison in, I think, North Carolina. During the course of that hearing, the father admitted, agreed, or whatever you want to call it, that $200 per month is probably the appropriate level for child support. The Wayne County Circuit judge, for whatever reason, and I can kind of guess what it was, said that she was not going to order child support while the father was in prison. The proposed child support order that was prepared and provided to the court had the income of both the father and mother and what the child support guidelines resulted in. My client making over $100,000 and the father making $18,500 plus while he was in prison. That source of income while he was in prison was a disability payment that he was going to be entitled to for the rest of his life. And so he did have an income while in prison. But for whatever reason, the Wayne County Circuit judge says, I'm not going to make him pay cash support. And my guess is that there's going to be an enforcement issue while he's in prison out of state. And so they left it at $0. That means in our case, the termination case, the court has to make that determination as to the ability to pay and whether that payment is substantial. The father provided health care coverage as did the mother. And the father's health care coverage cost him nothing. It was provided by the government. It didn't reduce his income, the 18,500 he was generating from the government for disability during this 2-year look back period that we're supposed to look at, didn't reduce his income. So essentially the healthcare insurance cost the defendant nothing. And I say the father, nothing. Therefore, the 18,500 that he was earning, none of that was provided as part of child support, the daughter. Even though the support order says $0, when we're looking at termination issues, the parent has an obligation to pay support. They can't rely on the fact that the support order says 0. That's why the trial court has to make the determination as to ability.
So even if he's not in violation of a support order that says 0, it's your position that he should be paying at least, let's just pick $100 a month out of the 18,500 that he gets a year. Is the 18,500 going to escrow? Does it go into an account? Where?
It goes into an account that he has. And,
okay.
And it is my.
And I get there's logistical issues for him to be able to actually obtain. I mean, is that, if I remember right, is that part of the problem? He said, yeah, it's there. I just can't get it.
No, that is not the problem.
Okay.
If the court looks at, goes back to my brief, you will see that in this 2-year look back period, his account had $48,000 go in and out of it. He assigned various people to be in charge of his account. He had 3 friends and a mother, and at one point, he was probably feuding with his mother and didn't want her on it. But
there's some assertions that people may have taken money out that they weren't authorized to take out.
There are some assertions of that.
Do you know at the time of this hearing how much was in the aggregate accounts?
At the time of the trial, I don't know what the final dollar amount was.
Roughly. 10,000, 20,000.
I'm going to say 7,000, but okay. I'm kind of.
But you think there was something in there that he could have been authorizing like $100 a month or something?
There was, but understand that the trial time period is way beyond that 2-year look back period, because the 2-year look back period is 2 years from the time of the filing of the petition. The trial occurred a year and a half later, 2 years later, whatever it was.
And at the time of the look back period, there was considerably amount.
$48,000 went in and out of that account in that 2-year period. So my argument is that, and let me say one more thing first.
Well,
the trial.
Hold on. So 48,000 going in and out. I mean, did he at any one point, was there a considerable amount of money? Because I mean, you could 5 in, 500 in, 500 out, 500 in.
As I recall, there was times where there was over $20,000 in that.
Okay.
The trial court's conclusory statement at the end of the trial was that based on the totality of the circumstances and father's ability to pay, I find that the provision or providing of healthcare insurance was substantial support. Court doesn't say whether he had any ability beyond that to pay. And I think if the court, reviews the law, it is clear that even when you have a support order that says $0, the trial court has to examine the ability to pay and whether it's substantial. Now, earlier I mentioned the situation where there is a supporter that provides a requirement to pay cash. And the ability to pay and what is substantial is baked into the support guidelines. And so I think a perfect thing for a trial court to do is to take a look at the income, look at the support guidelines. It doesn't have to be that specific number, but the guidelines give you an idea of the ability to pay and whether that's substantial. The trial court should have ordered him to pay some cash support, $18,500. I'm sure the judges know that there are many divorce cases where somebody has a paycheck of $18,500. They pay cash support. It may be very small, but they do. So I believe that the trial court erred because we don't know if the court found that there was an ability to pay or not. She just said based on the totality of the circumstances and the ability to pay. Does that mean there was no ability to pay? So from a legal standpoint, she failed to articulate whether there was an ability to pay. But even if she did say he had the ability to pay, the court should have found that he didn't pay substantial support because he paid no cash support when he had the ability to do so. The other issue, of course, is the contact issue. Over the 2-year period before, the court has to find that he failed when he had the ability to have regular and substantial contact with the minor child. And again, this is the 2-year period that he has to do that for, and that's the 2 years before the petition is filed. Granted, the father's in prison. Father's deposition was taken before trial, and during the deposition, he was asked repeatedly about his attempts at contact with the minor child. And he spoke of 1 or 2 letters over, 2 or 3 letters over the 2-year period. He talked about a phone call that he made to the minor's mother, my client, and basically confirmed during his deposition he made very little attempt to contact this minor child. Understand that my client's position has been the same throughout. There have been no attempts at all by the father to contact this child. When we went to trial, the father's testimony was, I sent hundreds of letters. I made, I think he said, too many phone calls to count, too many attempts to contact, and so on and so forth. His deposition testimony and his trial testimony is totally different.
Well, but again, the trial court found a lack of credibility by your client, and credibility, I mean, you know as well as I do that that's something that appellate courts don't pierce. The trial court is the one who's in the best position to make those credibility calls. We don't get to see the testimony. We don't get to have the person before us. So why, if this came down to credibility between the father and the mother, on what basis can we undermine that on appeal?
Well, I think the judge's factual finding was totally erroneous, because if you take a look at all of the testimony, including the impeachment that was done with respect to the deposition testimony that he previously gave, that you just have that I can't remember the legal words you used, but you just have a firm belief that it was the wrong decision. The father said almost no contact attempts in 2 years to hundreds and thousands of contacts during the course of trial. Father produced phone records that he says were my client's cell phone records. If you take a look at those cell phone records, they have a bunch of symbols on them, and it has duration of phone calls. There was no description, no testimony at all with respect to what do those symbols mean. And if you take a look at the call duration, it's all 0. Were they calls that were hung up before my client was able to answer? My client says she never got those phone calls. The father testified that I made many calls.
But again, the trial court made a credibility finding.
Judge, I can't dispute that.
Okay.
But I think there's just a clear feeling that it was the wrong decision. Judge, and I acknowledge that.
I guess what I'm suggesting is the contact issue, it's a harder bar for you to pass here because of the credibility findings of the trial court. I think the other issue is kind of a more cleaner question of law that we don't have to defer necessarily to the trial courts.
Judge, I agree with you 100%. But I think the word is the firm conviction that an error has been made. And I think that if you take a look at everything from the trial, the deposition, there's that firm conviction. I just can't believe that you can go into a deposition. Oh, and during the course of the trial, when he was asked, why did you change your deposition? He says, I must have been mistaken. You've got 2 issues that you have to address for the trial, for the deposition. 2 issues, support and contact. And so for him to say during the deposition, I had not made these attempts, and then say, I was just simply mistaken. It was really hundreds and thousands of attempts. I just find it hard to believe. Judge, I'd ask the court to reverse the trial court, remand it back with instructions that the court should make a determination as to the ability to pay, or find that the court made clear error in not ordering or saying that there was not substantial support because there was no support provision requirement, where she found that he paid substantial support even though he wasn't paying cash. And frankly, Judge, I'd ask the court to just remand, saying that the decision, the factual finding, was clearly erroneous.
Okay, thank you.
Thank you.
You'll have time for rebuttal. Miss, is that Fabio?
Yeah, Fabio. Yes, Your Honors. Good morning, Your Honors. Thank you. Paige Fabio appearing on behalf of appellee Alex St. Clair. Thank you. In regards to rebuttal, Your Honor, first in regards to the first prong about whether or not the financial benefit conferred to the child was substantial, we do agree with counsel in regards to when we are faced with a child support order, and again, the child support order entered in Wayne County that it was set at 0, we have to look at substantial in the context of ability to pay. One case that we felt was very helpful and on point in Ray Cologne, that was a situation actually where there was a child support order and there was a definite amount that the payor was supposed to pay every month, which for all intents and purposes should have been an easier analysis. Let's look at how much was paid versus how much was ordered. However, even in that court, the court indicated, had he offered evidence to satisfactorily explain his failure to comply, the probate court could have properly declined to terminate his parental rights. And that was in the matter of Cologne 144, Mishap 805.
But so I think, the insurance issue is pretty straightforward. It didn't cost him anything, but it was still a benefit to the child that the child was covered under this insurance that I think your client got through military service or something along those lines. But what about, I think, opposing counsel's argument, which does have some force, that your client had access to thousands of dollars during this 2-year look back period and didn't give a dime. And I get, the order didn't say he had to, but, as a parent, he didn't, send $50 a month, didn't send $100 a month. By all accounts, sent 0 out of this amount. Why does that not undermine your client's position?
I think for 2 reasons, Your Honor. First of all, in the court case that I referenced, even where there was a support order, the court was allowed to look at mitigating factors in regards to measuring ability. In our situation, there were a bunch of mitigating factors. My client was incarcerated during the 2-year look back. There was ample testimony placed on the record that he had to utilize a third party in order to try to direct management of his funds, and it was often to his detriment.
Well, okay, and I get that, but is there any evidence that he even made the attempt? Did he tell his mother or tell one of the other persons, hey, can you send my kid $50? Is there any evidence to suggest that he made any attempt to support his child financially?
We would rely on the consistent phone calls that he attempted to place to Miss LaPointe, while the bank records demonstrated that money was leaving the account through cash apps. Cash apps are not a magic wand when the recipient will not engage with the conveyor in any way, shape, or form.
I don't know what you're trying to say.
What I'm trying to say is, for example, the vehicle that was used to move the money, these cash apps, in order to send money to someone via cash app, the recipient has to download the app, set up an account, and communicate to the sender what their username is.
Okay, I get that it's hard, it's difficult. My question is there any evidence in the record that during this 2-year period, he made any attempt? Did he write a letter to his ex-wife or the mother of the child and say, I'd love to send you $50, here's how you do it, here's the app? Or did he tell his mother, can you reach out to the child's mother and tell her I'd love to pay $50 a month? Is there anything in the record to suggest he made any attempt to support this child financially?
And again, we would rely on the phone calls that went unanswered.
Well, did he testify that he was trying to accomplish that task in any of those phone calls?
He testified that he was trying to reach out to his minor child, but in regards to your specific question, he did not say on the record, I was trying to reach out to Ms. Lapointe for the purposes of sending her money.
I mean, the same, it's, so Mother's Council on the issue of contact has a difficult position because of the credibility. So I think you have a fairly strong position on the contact for that exact reason. But on this 2-year look back, I mean, he did have money. And by all accounts, there is zero evidence that he made any attempt to give any of that money to the child.
And I hear what the court is saying, and I will move on because I don't have that testimony. I don't have testimony or evidence to
So I
satisfy
think
your
you really do have to, the only thing you have on your side is this insurance. And maybe that's enough because again, medical insurance is extremely valuable in terms of having that coverage. So why does that medical insurance all by itself sufficient for your position?
Well, because medical insurance translates into real money saved by the insured. And there was testimony actually at the trial. There was testimony that he persistently and consistently monitored that insurance to ensure that his daughter was fully covered with the 2-year look back, even when Ms. Lapointe was disenrolling her. And there was also evidence that was presented at trial that his insurance, despite Ms. Lapointe's position to the contrary, actually provided a better financial benefit than her insurance did. There was a doctor bill that was admitted into evidence. I believe it was at the trial court level, petitioner's exhibit. And it showed that his insurance was in place. I think $113 of the visit was covered. She then took the insurance off, put her insurance back on, resubmitted the bill, and that insurance, her insurance at the time only covered $93.
Okay.
So, and again, I think that's, again, just speaks to the pattern of behavior that seems clear between the parties. My client's persistent attempts to contact and have a relationship with this child, and Ms. Lapointe's consistent attempts to deflect, obstruct, and not allow there to be contact or financial support.
Was there evidence that the father's insurance on the child was still financially better than the mother's in some respect, even though, because it wasn't an out-of-network?
Those were claims made by the plaintiff at the trial court level, but it's our position no evidence was provided to support that. And the one doctor bill that they provided that was submitted into evidence, again, our position is it in fact refuted that. And that was, I can refer to the exhibit at the trial court level. Exhibit 5A. Not to belabor the court's time, but again, in regards to the issue about contact, the second prong, I think the record was clear at the trial court level that my client made consistent contempts, not only by phone, he sent some letters, one of which Ms. Lapointe testified she returned without opening, and also tried to use third parties to have contact with his child, including hiring a law firm to fight for parenting time in custody while he was incarcerated, and also utilizing his grandmother, who had been a primary caregiver for this child, to bring the child to the prison so that he could have contact. And that was evidence entered into the record via testimony.
All right, anything else? Any questions, Judge Wallace?
No.
All right, thank you.
Thank you, Your Honors.
Thank you.
You have time for a brief rebuttal? And what about, why is the insurance not alone sufficient to show substantial financial support?
Because he had $18,500 worth of income
Well,
without that costing him anything. And
right, so let's set that aside. I mean, I think you heard my questions, but setting that question aside, I mean, medical insurance in this day and age is very critical in terms of, having a healthy life in America. And, the father did provide medical insurance for the child. Why isn't that alone a substantial benefit? I mean, the mother, I understand also had some insurance, but the mother might have been able to save some money by not having as much insurance. So I guess, why isn't the medical insurance by the father substantial?
There's no bright line rule in Michigan that says that if you provide healthcare insurance, you've provided substantial support. And as I recall from arguing this before the Court of Appeals, support is a relative thing. You take a look at one parent's income compared to the other parent's income. As one parent's income goes up relative to the others, the support goes up.
So it's really the fact that he had this other accounts of money that this medical insurance just wasn't substantial, even if it was something.
Had father's income been $100 per year, there is a strong argument that he provided substantial support. But you have to take a look at his resources to pay support. Otherwise, a person with an income of $1 million a year could say, hey, I provided healthcare coverage. That's substantial. Well, it's not in the relative scheme of things because you have to look at both of the parties' situation and his ability. Okay. He has the ability on top of the insurance to pay support. Thank you.
All right. I think we understand the issue. We very much appreciate you coming in, answering our questions. It's an important case. And again, we very much appreciate you coming.
Thank you.
Thank you. That case is submitted. Calling the last case on our docket today, docket number 375814, In re J. Brandon Minor. No parties are endorsed. That case is submitted on the briefs. And that ends our case call for January 2026.